Further hearing in the appeals, Warner-Lambert Company LLC.
Lord Swissborn claims, as you know, the general form of the claim is the use of drug X in the manufacture of a medicament for illness Y, and it's common ground they're often referred to as purpose-limited claims. And of course, my lords, the purpose that's being referred to there is the purpose of the medicament manufactured. In the patent world taxonomy, they are process claims. They are to using the...
To make the manufacture.
Yeah, exactly.
Yeah.
They're to use the drug to manufacture the medicament. And I thought it might be helpful for my lords to see what in my submission is a helpful explanation as to why we have them and the broad problems that they cause in a case of Bristol-Myers Squibb, which is Authorities Bundle 13, tab 153, page 5789. And we can pick it up on 5807, where Mr. Justice Jacob turns to explain about the claims. At paragraph 43, this section starts. And the first point I wanted to draw my Lord's attention to is paragraph 44, where the judge identifies the two hurdles that are sought to be avoided by the claims, and my Lords know that. They're the requirement of novelty and the exclusion from patentability of the method of treatment. And the aim is to steer clear of those obstacles. And you see in paragraph 44 the SI case, which is quoted at around line 35. And that is, of course, the case where the claims were first recognised and approved in the EPO. And that quote recognises that the claims being allowed applied to cases where the process of manufacture as such does not differ from the known process using the same active ingredient. And my Lords will have actually understood that must be so in the ordinary case because there are no details of the manufacture process in the claim at all. So that's necessarily so, unless you have some special tweak. And as Mr. Justice Jacob explained here, that the enlarged board rather ducked the issue of infringement by saying that it was not for them, which you see in the passage bridging that and the next page. So it starts right at the bottom and over to the top of the next page. And at the end of that paragraph, which is paragraph 44, Mr. Justice Jacob thought that that was rather unhelpful. And there are two reasons for that. Firstly, although the law of infringement is a question of national law, i.e. what acts amount to infringement, the scope of the claim is that very thing in patent law which links the two together. So the scope of the claim is a matter of EPC issue, an EPC issue, because you need to know that in order to decide validity issues, and that's one of the points that the learned judge makes there. But he also says to do something on one side, leaving an intractable problem on the other side, is not helpful. His lordship goes on in paragraph 25 to point out the difficulties, which he says are obvious, and he gives, as an example, a newly discovered use for aspirin. How can the manufacture be rendered new by adding a new purpose? And but also the point I emphasise here is that, of course, this is not just a theoretical issue, because the knock-on effect of that point is that there then will be a monopoly that's liable to cover the old activity. And finally, in this helpful explanation of the genesis of these claims, his lordship summarised what the effect of the Patents Court case in Wyeth was. And that was where the Patents Court sat on bank and expressly said in its judgment that it thought the better view was that Swiss claims didn't give novelty, but because of the desirability of achieving conformity with the EPO, they were upholding the claims. And as Mr. Justice Jacob explains, that's an example of the principle we actually see in other cases, for instance, explained by Lord Hoffman in Merrill Dow, as to the great persuasive authority of decisions of the expert court of the EPO. And so, against the better judgment of the Patents Court, we have them. I do pause here and invite my lords to note that principle, though, because that is going to be an important principle when we come on to deal with the specific points on sufficiency and plausibility, and in particular, when we look at my cross-appeal and on the application of the SALT authority from the Board of Appeal in the EPO.
So what is the principle?
The principle is of the great persuasive authority of the EPO authorities.
I see. Yeah.
Because of the need for conformity. And this was an example of it happening where, in fact, the Patents Court did something, uphold Swiss form claims here, thinking actually it wasn't the right thing to do, but it's the lesser of two evils.
Did anyone subsequently challenge that on appeal?
I don't believe so.
In any case?
I don't believe so.
No, so nobody's challenging it today, so...
No, we're not.
We're all going along with...
But they've been here for so long now, my lord, that the consequence of that would be...
disastrous.
Very, well,
yes.
It would be very substantial to say that they were all invalid just because they were Swiss form claims. Now, my lords, I think, have my submission from yesterday that once one gets into this judicial fudge, you're necessarily going to have to strike the right, as in fair balance.
I think you can take it that that's a phrase that we're going to find attractive in terms of a judgment.
No, I take the admonishment, my lord's
No,
absolutely right. But it has been referred to that as that in the courts below, and it's a handy phrase which my lord's right. I shouldn't fall into using.
Well, I can't speak for all my colleagues.
but that's what we.
Yes. Anyway,
we have something.
We see the basis.
But you have my submission that what we're necessarily going to have to do is to strike the right balance in my submission, as in fair. And you have my submission from yesterday as to when one sees the policies in play in the patent system, which are finely balanced, one should try to hold that same balance. I go further and say that, in fact, you see similar considerations coming into play, specifically in the approach that you have to take. For instance, to the scope of the claim, my friend took you to the protocol on Article 69 yesterday. I'm not going to ask you to turn it up again, but I'll just remind you that it includes in there reasonable certainty for third parties. This is a question of scope of the claim, so that is going to be part and parcel of the exercise. And another thing that my friend took you to was the enforcement directive, and you will recall that Article 3.2 requires the avoidance of barriers to legitimate trade, which is exactly what we're going to get onto when we look at the infringement issues. Now, my lords, before I get into the detail of the case on sufficiency, I have a few remarks as to plausibility, if I may. Plausibility is a label that we use to refer to a requirement as to a standard of the information that is contained in a document. And it's used in at least 3 different situations. Sufficiency is obviously the one that we are concerned with, but it also arises in inventive step cases, as my Lord Reid picked up on Monday when my learned friend showed you a case that wasn't sufficiency at all. So it's used in that different context too, and it's used particularly in the EPO because in their case law, what they like to do is to ask whether inventions solve problems. And so they often ask on the obviousness assessment, which may be a product claim, for instance, does it produce a technical contribution in the sense of is it a solution to a problem? And it comes into play in particular where a patentee might be trying to claim something which may be, say, a random new chemical or a molecule, a biological molecule or a protein or a fragment of DNA. And the point is very broadly this: one needs to contribute more than just the existence of the thing. And in the context of what I've just described, the solution to the problem, what they like to see is that it does something, i.e. it solves a problem. So plausibility in that context is usually a question about whether a particular problem is plausibly solved by the alleged invention. Plausibility may also arise in the case of a selection invention, and that's a special type of invention where one can get a patent by selecting a small class from a previously disclosed wide class if you're identifying a subset with specially advantageous properties, and obviously one which has not yet been singled out previously. And there the whole invention is based upon this technical effect, and so one can't get a patent on a selection unless one's contributed that. The label is also used to identify considerations that arise in industrial application cases. That is in fact a very rare objection. It's a separate requirement of patentability. It's not one of the gang of four that I took my lords to yesterday, but there are others that are rarely raised. And my lords have seen that HGS, the case in my lord's court, was actually about that. It was about a new protein, and the question was basically, is it of any industrial use at all? Now, my lords, the issues that arise under that label plausibility are, of course, similar. But one must never forget the context in which you're asking about plausibility and what for. And in our case, it's as to sufficiency of disclosure, i.e. the information contributed by the patentee. Now, my lords, it's convenient to deal with the post-published evidence rule now, because as you'll see, my answer to the point that's put against me is my friend is ignoring the fact that plausibility applies and arises across this broader range of cases. And can I take you to the case that establishes it? And it's Johns Hopkins, so it's Authorities Bundle A6, tab 64, and it's page 3464. And I'd like to pick it up, if I may, at 3469. Where you see the heading Reasons for the Decision, and you see from the heading just under that, immediately you see this is an inventive step case. It's not a sufficiency case at all. And you actually see from that rather long heading in italics that it's about a molecule, polynucleotide. So it's a product claim. And just to summarise, the argument, to put it very shortly, was whether the claimed molecule was a member of a particular superfamily that had particularly advantageous properties. So it's that kind of case that my learned friend, Mr. Mitchison, identified, a superfamily case. And the question on inventive step boiled down to whether it was plausible that the molecule was a new member of this family, and you see that at paragraph 6 at 3470. And very broadly, the argument that was advanced sought to draw on structural similarities. And you see that that failed on the facts. You can see that at the end of paragraph 8. The molecule couldn't be clearly and unambiguously identified as a member of the TGF-beta superfamily using the structural approach. So that was a way of trying to establish that that's what you're contributing. The next paragraph, paragraph 9, mentions...
Is that a question of plausibility? It's a question where the patent didn't identify correctly the subject matter, isn't it?
No, my lord. First of all, don't forget it's an inventive step test.
Yes.
And what was being put forward was this polynucleotide, and it was said this solves a problem, and the problem is to identify a new member. And actually, I think you see the problem at 4. If you look at paragraph 4, you can see very clearly the way they'd analysed the problem. And so what they were asking themselves, is it plausible that this has solved that problem, i.e. identified a new member of the family? And one way to try and do that was to point to structural similarities, but that failed on the facts, and that's what I was trying to identify for my lords at the end of paragraph 8. There was an alternative way that
Are they, and what do they mean by plausible here? Do they mean whether or not it is correct? If
no,
they mean
whether
whether or not it's correct, then it's
no, whether it's plausible that it's true.
see.
As I understand it, if it was a member of the same family, then it was plausible to think that it had the same therapeutic characteristics. So the question of fact was whether it was.
They're not even going to that second stage, my lord. They're simply saying that it is inventive if you've... One of the things that industry wants to do is identify more members of this family that's good.
It would be inventive if it were true, and it is.
Indeed.
The inventive step is in itself identifying this as a member of the family?
The inventive step is providing the molecule and the technical contribution that it is a member. Indeed.
Does it necessarily follow from the fact that it's a member of the family that it has the relevant therapeutic effect?
No, it doesn't even have to be a therapeutic effect in the case.
The relevant beneficial characteristic?
No, it doesn't. It doesn't. But for inventive
so
step...
it's a plausibility point and not a conclusive finding.
Yes, it's a plausibility point.
Is it not the case that they were simply saying, if it's a member of the superfamily, then it's plausible to think that it has the relevant beneficial effect?
No.
Right.
I can see that you could ask that as well. They're actually asking the first question, is it plausible it's a member of the superfamily?
On the face of the patent.
Yes.
It may be...
Because
So
it's
there's a
likely...
double plausibility stage, is that right?
Yeah. Well, they're asking, is it plausible? If you assess the point as a problem to identify fresh members, is it plausible you've done it? That's all they're asking. That's all there are. And now I do accept the point my lord's putting to me is, even if it is a member, it might be one that doesn't have quite the same properties as others. But they're not going that far. They're just asking the question, is it plausible that actually what you've done is not a random molecule, but it is a member of this superfamily?
It seems to me paragraph 12 is probably clearer and more helpful.
Yes, we were going to get there.
Good. Sorry. We have had cited to us, it's not a question of blame, but probably an inevitability with this amount of material, but we isolated bits of quite a lot of cases which need to be put in perspective.
Johns Hopkins and Salk are two cases that you weren't taken to, and they are absolutely central.
These are central, yeah.
Absolutely central. Now, the reason I was showing you this is that there was an alternative approach that might have been tried, which is mentioned in paragraph 9, but there was no evidence at all in the patent on that. So you see that at the passage bridging 3470 and 3471. And if you drop down to paragraph 11, what they had with the after acquired evidence was a functional argument. So this was evidence which was more than speculation, but it was post-published.
Yeah.
So this was not the structural one, but some evidence about functionality. And that's where paragraph 12, which my Lord Mance has identified, comes in. And in particular, the sentence bridging the page, they say that the approach, that's looking at later evidence, would contradict the principle that patentability must be assessed at the date of the patent. And the key thing about that is that you must have made a contribution to the art at that point. And you'll recall from yesterday, that's one of the basic principles I've identified, and it's going to be a recurring theme. And that's just another way, my lords, of saying you can't claim an area from the public if you've not made a contribution covering that area at the date of the patent. And that's important because that's one thing that you've got to do. You've got to at least have made it plausible in your patent at the date of the patent. But if indeed it turns out that the technical contribution is not there, i.e. that what you've made plausible turns out not to be true, that can also be relevant. And that's quite important, because the way my friend puts his argument against me is that there's no point to after acquired evidence. He says it must be to allow me to make it good later. But he's missing the point that these rules as to applying, these rules apply as to showing a technical effect in much more broad circumstances than sufficiency of Swiss form claims. And in particular, why I've emphasised to my lord that, for instance, it covers product claims. The point is, a product claim would be a monopoly to the product, where there might be a point to a fight of somebody coming along afterwards and saying, you haven't contributed anything, it's not true. And the reason that there's a point to the fight on the product is because they might want the product for a different purpose. That fight will never arise in a Swiss form claim case, because it's always true that the Swiss form claim is right. By that, I don't mean it's always true anyone that applies for a Swiss form claim must be right, but one never fights about the other ones because it never covers anything that's of any use to anybody. And you see in the cases that it is relevant afterwards to assess whether or not there is a technical contribution, and somebody attacking that is entitled to put in evidence, and the patentee is entitled to put in evidence. And the patentee may establish conclusively that it does work, the technical effect is there, or they may still only establish on the balance of probabilities that it's plausible. So it may still be a plausibility threshold. But the fact of the matter is, there are two relevant things going on. There is the question of whether or not you've made the contribution in your patent at the date, and then there's the question later as to whether or not somebody seeks to challenge whether there is in fact a technical contribution. And as I've explained to my lord, that second thing doesn't, as a practical matter, ever arise in a Swiss form claim, and that's why my friend can put this rather attractive, oh, it's circular, you never need it. There are cases when you do.
Just say again why it doesn't arise in a Swiss claim?
Because the technical effects, a party wouldn't be coming along to court saying there is no technical effect, technical contribution, because the claim is limited to, in effect, say it's the treatment of pain. I wouldn't be coming along here trying to knock out.
Because you know whether it does or
yeah, exactly.
Work,
exactly.
Because then what is the position if, in relation to a patent, later it's plausible, it's sufficiently plausible as described in the patent, and later evidence does no more than confirm that it's plausible? You said a moment that was a possibility. You said a moment ago that was a possibility. What's the position then? Do you fail because you haven't established a technical contribution?
No, my submission, you would keep your patent.
But you would keep it by reference to the initial plausibility rather than the subsequent
Yeah.
information.
But both.
Both?
Yeah.
But why do you need, if you pass the plausibility test, why do you need the subsequent information?
It's for a different part of the assessment where the other side have come along to try and say...
You're trying to rebut a suggestion is it was plausible, but it's actually useless.
Yeah.
Yeah.
Exactly.
In other words, the person opposing the patent can come along with later evidence to show that notwithstanding an apparently prima facie plausible problem-solving description in the patent, actually it doesn't work. But if you, the patentee, can show on the evidence, well, actually it does work, then that attack is fended off.
Exactly.
Yes.
That's exactly the point of it. And you'll see it. I'm going to take my lords to very shortly in Regeneron in the Court of Appeal. You'll see that's recognised. And so actually when I come to that way my friend puts the case, it's going to be very short because that is the answer. And the reason I dealt with it there is because it fits nicely on the back of showing, my lords, that there is a range of situations where plausibility arises, and some of them will be cases where you will have a fight about whether what was plausible in the patent is in fact true. Can I just make a few remarks on the plausibility in this kind of case? Can I show you Mr. Justice Burse in Hospira and Genentech? That's the Authorities Bundle 2, tab 25. Page 2058. And there's a helpful section at para 56 to 64.
I'm so sorry, can you give me that page number again?
I'm sorry, well, the page where the section is, it's 2069.
Thank you.
So this was a Swiss form case, and the judge was explaining a little bit about the problems or the issues of sufficiency. And the first thing that the judge explains in paragraph 57 is an important point and not an easy thing to grasp. Paragraph 57 explains that the achievement of the therapeutic effect, so in this case it was the treatment of a particular type of breast cancer, is a functional feature of the claim. And we'll see that again when we get to Salk. What does that mean? It is important because it's often relied upon by patentees to avoid the prior art. And what it means is that you actually have to show that it works. And so it's often relied upon by patentees to avoid the prior art by saying that a suggestion in an earlier paper or patent that something might or even should have a particular effect is not the same as showing or disclosing that it has in fact been attained. And so patentees say the claim is not deprived of novelty by a prior art suggestion, i.e. it doesn't give enough knowledge if the proper construction of the claim is that actually attaining the therapeutic effect is an integer of it. And in the ordinary case, in Swiss form claims that, for instance, don't say working in animals is good enough, the argument is about showing it has a therapeutic effect in humans. And in fact, my Lord C, Mr. Justice Burse explains this attaining the effect issue if you drop down to paragraph 59. As he says, it can be said that a document does not disclose the treatment is in fact efficacious. So patentees often rely upon this to say something that makes it look really obvious. Oh, it doesn't actually hit the claim because although it's saying it has the effect or it will have the effect, what it's really saying is they think it should, and that is not actually disclosing that it does. And as you see at the end of paragraph 59, the judge goes on to say whether the proposal will render the claim obvious is another matter. And just so you see the bigger picture there, patentees often say that suggestions that a drug will or should work doesn't even reach the standard of reasonable expectation of success, which is the standard of obviousness cases. And so they say, unless there's evidence in a document that makes the skilled person consider that there's a reasonable expectation that the effect will be achieved in humans in a clinical trial, they say there's no obviousness objection either. And Mr. Mitchison was quite candid about these submissions of that kind when he talked about why he was saying it had to be to the standard in phase 2 clinical trials when he made submissions to you on Monday. That's quite an important thing about the standard of knowledge that actually you need to have to get in these claims. Incidentally, my lords, the paragraph I've jumped over is worth noting because it says something about construction of the claim relevant on infringement. You'll see it was common ground, so I can't make too much of it, but it is notable the judge and both parties were perfectly happy with the construction that for meant suitable and intended for. Now, in paragraph 60, Ms. Justice Burse explains the potential for the patentee having to include clinical trials, following on from what I've just described about how the claim actually requires you to show that it does work. It's a technical feature of the claim. You would have thought that you'd have to do that. But he explains that they're expensive, and indeed the existence of patent protection may facilitate the investment, so it would cause difficulty. He goes on in paragraph 61 and explains that if all you have is a proposal, there is no contribution to the art. That, he says, is not disclosure of the claim properly construed. And the reason he puts it that way is because the claim properly construed requires disclosure of the actual attainment of the effect. And the last sentence of paragraph 61 is interesting. It's pointing to quite a big problem, that if you allow a situation where a mere proposal is not enough to invalidate a claim, but that's all you have to get the claim, there's a problem. And this, my lords, is the argument that the standard for plausibility must be the same as that for obviousness, i.e. reasonable prospect of success. And the reason for that, my lord, is otherwise you would face an absurd situation that the monopoly can be secured with the disclosure that itself wouldn't invalidate it if it was prior art. I hope my lords see that. It wouldn't invalidate it on novelty or obviousness grounds, because it's a proposal that it should work or could work, but unless it meets the reasonable prospect of success test, it wouldn't be enough to hit it on novelty or even obviousness. And that's the point of debate in patent law.
Well, because prior art involves what? Inherently some degree of proof or plausibility.
Exactly. And what I'm postulating to my lord is, in fact, quite starkly put...
It's prior art, otherwise it's just a proposal.
Well, but you could contemplate the patentee just applying for the same monopoly based on the same disclosure 6 months or a year later. I can have the claim. Is it non-obvious? Yes, because it doesn't disclose the technical feature, nor does it make achieving it something that the skilled person would have a reasonable prospect of success on. And that is the key problem if they're not the same. You arrange a situation whereby you can repatent on exactly the same disclosure. Now, as I've said, in my submission, it's not actually necessary for my lords to decide my cross-appeal in my favour to actually decide that point. If you just look at Salk and apply it, in my submission I win anyway. But to find against me, you would have to hold in my submission that the standard was lower than that for obviousness. And as I've just said, the big picture consequence there is of a possibility of a disclosure being enough to secure a monopoly, but not to invalidate it, and therefore, as a matter of logicality, the possibility of repetitive patenting on the same disclosure.
To find against your cross-appeal, you would have to find what? I'm just trying to get a note of what you said a moment ago.
Yes. Part of my cross-appeal is to say that the standard of plausibility should be the same as obviousness. That's one of the ways I put it. I also put
it's obvious it works across the whole width.
No, reasonable prospect of success.
So there's a reasonable prospect of... Yes, that's what obviousness means.
Yeah, exactly. But I also put it on the basis that you just look at Salk and you see what they're saying there about, I'm jumping ahead a little bit, there's a particular way in which you might seek to show plausibility indirectly by reference to a mechanism, and that's what Salk is all about, and that's what this case is all about. It's on absolutely all fours. And so what I do say is that you can avoid that question by just looking at Salk and applying it. I win just doing that, whether or not it's the same standard.
But to find against your cross-appeal, we would have to find what about obviousness?
I say that the right standard for plausibility is obviousness, i.e. reasonable prospect of success. So that's one of my submissions, is that that's the standard that you should be applying. And then when you look at the patent, it comes nowhere near that. Nowhere near that. So that one of my submissions is that the correct standard is the same as obviousness. My other submission is, don't worry about that. Salk, in any event, is quite clear. This is the way they're choosing to prove it, exactly what Salk says. And if you look at the detail, that's what you've got to do. And I'm going to come to that.
Sorry, what does Salk say? What's the
Okay, well,
principle
I'm
you
jumping
get
ahead.
from?
Salk says if you're going to go by a mechanism, you've got to show an effect of the drug on the mechanism, and they don't do that. But I'm jumping ahead now.
I'm slightly puzzled at the moment. I can see that the argument that a claimed invention was obvious it can involve considering whether, if somebody were to try to do the invention on the basis of what was generally known, they would have a reasonable prospect of success. But it's obviousness, speaking completely as a non-expert, seems a rather more complex concept than simply what the prospects of success.
You're quite right about that there are other factors that come in many cases, but in these kinds of medical Swiss form claims, basically the argument boils down to where you've got something that's a proposal, it might work, but would you do it with a reasonable expectation of success? So you're quite right, because there are many cases where you're not actually looking at a proposal, you're just looking at something which is a bit different, and you're asking, would somebody think to do whatever it might be?
So why should the same standard be applied as with obviousness? I mean, obviousness is where you have a patent which has a problem because it's the prior art shows, the prior state of knowledge shows that it's obvious that this method or this product, this process or this product had a reasonable prospect of success. Am I right? Up to a point.
I'm not quite sure whether you were saying that it was obvious and it did.
But if it's obvious, then you can't patent it.
Yeah, but I'll tell you
So,
why.
but why should that be the test of what you have to show in a patent when it's not previously obvious?
Right, because otherwise you with a disclosure of providing less knowledge to the public, secure the monopoly, and bring about the weird position whereby you could apply again with the same low level of disclosure.
Really, you've got to make it part of the art from that
Exactly.
point on. Yeah.
Yes.
Yeah, exactly. That's exactly it. And actually, it's all about knowledge. It's what knowledge the prior art gives the public, what knowledge the patent's giving the public. And it would be really weird if you can secure the monopoly with less knowledge than the public could say, well, I get it from this piece of prior art. That's what it's about. Now, right at the end here, my lords will see that Mr. Justice Burse in paragraph 64, the end of this section, says that for this reason, the idea of plausibility is part of the law of sufficiency of disclosure. It's been developed both in the EPO and the UK. And you see that he identifies Salk, it's the key case for the EPO, and Regeneron for the UK. And Regeneron there, if you go back to 57, you can see it's the Court of Appeal Regeneron, not the earlier first instance decision that we looked at for the very basic categorisation of sufficiency classes yesterday, which was Mr. Justice Floyd. This is the Court of Appeal. Can I take you to that first? Because there's one step more that I need to show you, and I get it from Regeneron. And this is a case that recognises that the width of claim considerations that we've seen about technical contribution apply in the context of plausibility sufficiency issues. And so it's bundle 5, tab 45, page 3002. And of course, my lords won't be surprised at the proposition that I've just explained, because if you think about it, it must be so if you're to keep with the key principle that the technical contribution must justify the scope of the monopoly claimed.
Well, it does. It depends on what time you look at it, doesn't it? I mean, you're saying that you've got to make it part of the art at the moment you lodge the patent, but I thought that the object of the patent was to make it part of the art in the sense that it will work, so that anyone trying it will then is enabled to try it, and it then, when it's used, becomes part of the art. So is that a possible answer to your point about the patent having to disclose obviousness itself? The obviousness arises when the patent, because the patent is enabled, and when it's used, it becomes obvious that it works.
I don't think it is an answer to the point I'm making, my lord, because just on the point of obviousness and plausibility, it was a point about the fact that you can't have the right balance in the system if you have a different degree of knowledge that's required from a patent document and a piece of prior art, and the strange consequence that flows from it that you can have repeated patenting.
So is there this is your best or good authority on this, is it right?
Well, this is moving on a little bit. I'm moving on to just explain why plausibility includes width of claim considerations as well.
Forgive me do correct me if I'm getting this wrong, but if I followed what you're saying that you can't patent a supposed, a claimed invention if it's obvious in the existing state of knowledge that this invention would have a reasonable prospect of success. But once you have patented an invention, the patent itself should add sufficiently to the current state of knowledge for it to be obvious to any skilled person that this invention would actually have a reasonable prospect of success.
My lord's got it. Exactly that.
And you say if the disclosure in the patent doesn't introduce into the prior art something which satisfies the obviousness test, then somebody just come along and do the same patent again.
Exactly.
You wouldn't be able, and the opposition wouldn't be able to say it's obvious.
Exactly. They turn up and say, no reasonable prospects of success, no novelty because the technical feature of the claim.
Yeah.
Please can I have another monopoly running for another 2 or 3 years. Now, my lord, the section that I wanted to take my lords to, it starts on 3.0.30. It's the legal principles of sufficiency, and it's paragraph 95 where the judge turns to this, and you see in paragraph 96, immediately the judge explaining that it's now well established that the scope of the monopoly must correspond to the technical contribution. Key principle. Paragraph 97 is an explanation of the degree of research or inquiry that can be expected in what one may consider classical insufficiency situations, i.e., can I make a specific embodiment in the patent work? The next topic, paragraph 98, is a point that, in fact, one can define an invention in general terms if you've disclosed a principle of general application. We touched on that yesterday. And you'll see, in fact, Hoffman and Biogen set out, it's the passage that I think we looked at yesterday.
Yeah. And indeed, that first sentence encapsulates the submission you've just been making, doesn't it?
Indeed, yes. Indeed. And you see in paragraph 99, Lord Justice Kitchen also quotes from similar sentiments from Lord Hoffman in Kieran Amgen. And that's why I said to my Lord yesterday, Lord Hoffman obviously liked the Genentech polypeptide case, because that's where he's talking about it again, explaining how it was of striking breadth and originality. And paragraph 100, Lord Justice Kitchen explains that it must be possible to make a reasonable prediction that the invention will work with substantially everything falling within the scope of the claim. And he says that the assertion that it will work across the scope must be plausible or credible.
Where does he say that?
I'm looking at 100, 4 lines down.
Yes.
Paragraph 100.
Thank
so
you.
Right
I've got that.
Yep.
Yes.
And then the products and methods within the claim are tied together by a unifying characteristic or common principle. So, my lords, to put it clearly, the unifying characteristic or principle idea that we saw in a Genentech polypeptide type situation is being put to work in the field of plausibility. And at paragraph 101, His Lordship explains that if it's not possible to make that prediction, or if it's shown the prediction is wrong, that's the after acquired evidence, so it doesn't work with substantially all the product or methods within the claim, then the monopoly will exceed the technical contribution and the claim will be insufficient.
Plausibility isn't actually a quality of the invention or claimed invention. It's a quality of the disclosure.
Exactly, it's the quality of the information, absolutely. That's why it's the quality of your contribution to the art, the disclosure, and that's why Dr. Fisher's article about the price of the patent is so important. Just so you see it, the final sentence in paragraph 101 is mentioning the possibility of obviousness, and that's the point that I explained to my lords about plausibility sometimes cropping up in obviousness as well, where the product has to be a solution to a problem. Sometimes in England we call it agrevo obviousness because after the case that established it. The next paragraph broadly says that where the limitations in the claim are functional, one still has to be able to perform it across the claim. And the final paragraph is an express recognition of and citation from Salk in the EPO. The quote is from paragraph 9, and we're going to look at it when we get on to my cross appeal, but it's important to note what Lord Justice Kitchen says about the quote. It's the sentence beginning nevertheless. So just before the quote, you see the nevertheless. Patentee must show, for example, the product has an effect on the disease process so as to make the claimed therapeutic effect plausible. I'm going to elaborate that, but I want my lords to see that there are two things there. The therapeutic effect is what needs to be plausible, and if the route that you're going to establish that is not directly on the disease or illness, but on a process or mechanism involved, in order to show that, in order to show the therapeutic effect is plausible, one must show that the product does have an effect on that process. And we'll look in more detail at that when we get to Salk. Now, my lords, my friend's appeal, however he tries to dress it up, his argument on sufficiency is that he is arguing he is entitled to a claim of neuropathic pain on the basis of data which is indicative of efficacy for inflammatory pain. And he's seeking to say he can have it by extending to neuropathic pain via a unifying characteristic of central sensitization On my cross appeal, I'll show you that that fails anyway. But for my friend's appeal, the point is that is something that has no application whatsoever in central neuropathic pain, a class of conditions itself, including important ones such as stroke and MS. He argues that he gets from inflammatory pain, extending through to peripheral neuropathic pain, and then on to central neuropathic pain. And however one dresses up that argument, my lord, one must see and recognise that it is an argument that is flat contrary to the proposition that you've seen described by Lord Justice Kitchen as well established, that the scope of the monopoly must correspond to the contribution to the art. My lord, the guts of each way he seeks to put it has at its root the following proposition, which is objectionable, that he can secure a claim that is broader than anything he has plausibly contributed in his patent. How does he put his case? As I understand it, now that he's dropped the argument that there's no plausibility requirement at all, he puts it two broad ways. Firstly, he says you must not look at the substance of what's covered. He says you mustn't salami slice the claim. I say it's hardly slicing it by recognising two distinct important categories, but anyway, he says you mustn't look at the substance of it, just look at the wording and the generality of the claim. My lords, you can rewrite that proposition thus: if he can frame his claim at a level of generality that does not correspond to his technical contribution, he can nonetheless have it. That's all it amounts to. The second way he puts it is to say he can rely upon the post-published data to make good the whole. Let me deal with the arguments in turn. The first has three principal flaws. Firstly, to try to knock it down, he overstates the correct test. As we've seen in Lord Justice Kitchen's judgment in Regeneron, he must be able to make a reasonable prediction as regards substantially everything. Not the way he puts the case in paragraph 71A of his case, which is page 163 of the bundle, that plausibility must be established for every possible condition covered. Secondly, and most importantly in my submission, my friend is overlooking the underlying reason for the requirement in Lord Justice Kitchen's test, namely that the class must be tied together by a unifying characteristic or common principle. Thirdly, and actually perhaps this is the same error, my friend seeks to argue that he gets home or gets some help from the fact that where one is considering classical insufficiency, it's not necessary to enable each and every embodiment covered by the claim. And that's a point he makes in his case at paragraph 75, Core Bundle 2, page 165. And he elaborates it with cases given over the page. Now let me explain why I say perhaps it's the same error. I thought that what you're looking for is the underlying principle characteristic. And that's because you can have claims that cover inventive contributions where that inventive contribution is using your underlying principle or characteristic. And it's precisely because of that that you can have it. And it's plain as a pikestaff in the cases that my friend himself quotes. If you turn over the page, you see the first quote, the fact that the claim may extend to further inventions which make use of the principle disclosed. You're making use of the principle disclosed or the knowledge contributed in that first patent. Let me give you an example. I'll try and give you one that's rather homely, but maybe this will work. If somebody invents a bicycle, obviously assuming that such a thing had been unknown, the claim could be framed in a way to cover a motorbike, even though the patent doesn't teach anything about the internal combustion engine or how to incorporate such a thing on a bike. You'll have a claim to integers which cover a vehicle that looks like a bike, and a motorbike would fall within it. Because somebody that comes along and makes the motorbike is using the principle that you've contributed in your bike patent. So that's why you can have inventive improvements. And there's nothing inconsistent with that in my submission, because you are using the information in that first patent, the general principle. You've got the unifying principle which goes up to make a bike, and somebody can perfectly properly come along and build upon that. So we perfectly accept that, but it doesn't help my friend, because the point is it relies upon there being a general principle or unifying characteristic in the claim or the original patent, and he doesn't get anywhere near that. And the same point's illustrated in the Genentech polypeptide case, which he cites at paragraph 77. Those are cases where the knowledge...
If you have a patentable improvement, the person making or devising, thinking of the improvement, can patent the improvement, but needs to get permission of the bicycle patentee, does he, to use the...
If the bicycle patent hasn't expired, yes.
Yes.
Yeah, exactly. Exactly. But those are cases where the knowledge contributed is the general principle. So, my lords, the crucial point, my lords, is the reason underlying Lord Justice Kitchen's explanation, the need for a unifying or common principle or characteristic. And if you provide that knowledge, then your claim can be commensurate with that. And that's also the reason why you can have claims where it's conceivable or even likely that there may be instances within that common principle that will not work. Let me give you an example. If you devised a new antibiotic, it may be very likely that there will be some instances of bacteria, either existing now or that come along in the future, that will be resistant to it. But if one is disclosing a general antibiotic activity, one is contributing that, and you'd be able to claim it as such. And the point about not working with some cohorts of patients is a similar point. As my Lord Sumption identified, it's not the same thing as throwing in other conditions for which there's no plausible basis at all. But it's a similar point, that if your principle is that you can treat these indications, it's just not to the point to come along and say there are some patients where it might not work. And in my submission, the similar considerations explain the Bristol-Myers Squibb case in the EPO that my friend took you to. Do you remember the CML case, the leukemia case? The possibility of some instances where, for whatever reason, in fact, it may not work, doesn't take away from the contribution of the general principle that it has therapeutic effect treating CML. All of these cases, there is a contribution of a common or unifying principle.
That's why, in that case, the claim that it treated a particular category of patient being thrown out didn't jeopardize the more general claim.
Exactly. Absolutely exactly. But where you're considering a case like this one, a use claim where there's no unifying or common principle that extends across the scope of the claim is bad.
Why was there a unifying or common principle in CML? I forget what they were talking about. They were talking about
general CML claim and then a claim.
it was right.
Treatment.
I see. Wasn't that, though, resistance or not, a characteristic not just of the patient but of the type of illness which they were, malady which they were suffering under?
But that would be very similar to the antibiotic case that I give you. The fact that you can foresee that there might be, or perhaps even very likely will be, exceptions to the rule doesn't mean that you're not disclosing that general principle to which there are exceptions.
But the exceptions presumably may be based on some distinction in the way in which the patient is affected, rather like the distinction between peripheral and central pain. Yeah.
Well, then you're postulating different facts, which we don't know.
Well, do we know that? I mean, is it just an assumption that it was a random distinction? Some people were resistant, some people were not resistant.
No, I'm not suggesting that, but what I'm suggesting is that you're postulating that there would be some point of principle which would make you think that actually, I think what you're saying is that there would be a point of principle that would think that you couldn't disclose a general therapeutic effect for CML.
Yes, exactly.
That's really it.
Some people are resistant, and there must be some reason why other people are not resistant.
But that's a question of judgment as to whether or not that is the information that's provided, a bit like the antibiotic example I've given you. All I'm saying, to my lord, is that there are cases where you can provide the knowledge which is a general principle, even knowing that there may be exceptions, but you're still providing that knowledge, that general principle. As I keep saying to my lords, it comes back to the fundamental well-established principle: the claim must correspond to that contribution. Now, another important flaw in my friend's argument is that he ignores on the facts that central neuropathic pain is an important and significant class of conditions. Can I just remind you how Lord Justice Floyd explained it in paragraph 121. So I'm in Core Bundle 3, page 574.
You mean Core Bundle 3, don't you?
Yes, did I not say that?
Yes.
No, you said one.
I do apologise.
No, it's probably the most important. Yes, 573. 574, right?
574 is the page, paragraph 121.
Yes.
Yeah.
Could you just read that?
I mean, it's slightly odd to treat CML as a case, going back to it, where the patients didn't divide naturally into these two parts, bearing in mind that the patent drew exactly that distinction. But you say, nonetheless, claim one could be regarded in that case as speaking of a single phenomenon,
Yeah.
even though claim two said it wasn't.
What it comes down to, my lords, is it might be a question of judgment in some cases as to the level of generality at which your principle is being contributed. But we see from the cases that what we're actually arguing about is what is the knowledge that you contribute, what is that general principle. So there may be cases where there is a question of judgment or argument, but the principle in my submission is very clear. It's also clear that Mr. Justice Floyd, as Mr. Justice Floyd explained, important categories in central, the point I wanted to go on and make to my lords is that this is actually how people look at it in real life as well, at least from the licensing point of view, because we know that for the marketing authorisation, they were granted for these conditions separately. Perhaps I could ask my lords to go to Core Bundle Volume 1, page 108.
Sorry, page?
108.
Thank you.
And it's just the footnote. The marketing authorisation was granted in July 2004 for peripheral neuropathic pain only. Other conditions were added later.
Sorry, can you remind me of the page?
Sorry, 108. It's the facts and issues, and it's actually just the footnote. Core Bundle 1. And it's footnote 5. Now, my lords, the second way the argument is put, I've pretty much foreshadowed my answer already, is that it's a rather convoluted argument that suggests that unless there can be some other purpose for the after-acquired evidence, the purpose is to make good deficiencies in part of a claim. Now, I've shown my lords that that's not the purpose, and that's it. That's just the assertion. I can do it because that's the purpose. What it's an argument about is that you can speculatively get protection, foreclose the area to others, then do the work later. That's all it amounts to. Or in fact, maybe don't even do the work yourself, wait for somebody else to do it. Where would one draw the line? And why, my lords, wouldn't it save Claim 1 as well? Now, Lords, there's a kind of broader point that infuses everything that my friend says about, there's a suggestion that somehow this is unfair. It's unfair to restrict them to that area whereby they've actually contributed something which is plausible. My submission is there's nothing unfair about not allowing them to foreclose an area to others and doing the work later. It's totally contrary to the normal balance in the patent system. And in fact, in my submission, it would be totally unfair if you allowed the kind of speculative claiming work later approach that my friend suggests. Now, my lords, that's all I've got to say before I get to my cross appeal. I'm obviously dealing with similar issues, but I was going to move on to my cross appeal unless my lords have any questions that I could help my lords on.
No.
So, my lords, I hope will understand that thus far I've been proceeding on the basis that in some part, some of the conditions in Claim 3 are adequately supported by the disclosure of the patent. And in my cross appeal, I challenge that. And this is the argument that the wrong test was applied as regards peripheral neuropathic pain conditions. Before I get into it, let me just explain the consequences if I'm successful. They are as follows. First, claims 10 to 12 fall to be revoked. Those claims are limited to specific types of pain that are peripheral neuropathic pain. Secondly, all the other arguments on Claim 3 actually fall away. That is my friend's arguments on construction and the appeal on amendment, so all the abuse arguments. They all fall away because Claim 3 covers nothing contributed by the patentee in providing its data in inflammatory pain models. So I'm afraid it makes all of the issues that my learned friend Mr. Saini will be addressing academic. And the answer is simply Claim 3 is, as it were, wholly bad rather than just partially bad. Can I start with some general points on nociceptive or inflammatory pain? I'm going to use the word inflammatory, as you can see already. I find it easier to say. And that category compared to the neuropathic pain on the other hand. They're very different things, as we seek to summarise in our table at paragraph 76 of our written case, and that's page 281 in the core bundle. The first class, inflammatory, is of a normal, i.e. healthy phenomenon. And these pains serve by a protective function and they go away when the underlying cause is resolved.
76 on page 281.
I'm sorry, 281 in
Thank you. Yeah.
Neuropathic pains are a class which are pathological, meaning there's some lesion or dysfunction, and they don't go away like inflammatory pains do. So at a very general level, we can say they all hurt, but they're very different. And importantly, it was well known that unless you're trying to treat a patient with opioids, treatments for inflammatory pain didn't work for neuropathic pain. We see the substance of that in paragraphs 16 to 17 of the Statement of Facts and Issues. That's page 110, where it's explained that there were many well-known treatments for inflammatory pains which are set out, but not so for neuropathic, and the things that are listed that were used for neuropathic are different unless you're going for the opioid cause. Pause there. What that indicates is you wouldn't naturally expect something that had efficacy for inflammatory pain to have any effect for neuropathic pain. More specifically, whatever ways in which the treatment of inflammatory pain was being affected, whether an underlying cause or one of the mechanisms involved, actually whether you knew about it or not, you wouldn't think that it would be playing a part in neuropathic pain or something which enabled you to treat neuropathic pain, or else you would have seen drugs that provided a beneficial effect across inflammatory pain and neuropathic pain. The next thing that I want to make sure you understand is the phrase central sensitization as used in this case. It is used narrowly to mean a particular amplification mechanism that was based upon a theory of Professor Wolff. You see that in the judgment of Mr. Justice Arnold, so I'm now in the third volume of the core volumes, page 746, paragraph 61.
I'm so sorry, page number again, please?
Sorry, 746.
Thank you.
And it's the top of the page.
Yeah.
And I'm actually looking at the second half of the paragraph.
61.
Yeah, 61. You see in the middle he says the first. So the first way and then the second way this term could be used. And he's using it in the first narrow sense. But that same paragraph explains that there are other central amplification mechanisms or augmentation mechanisms, and that sometimes the phrase was used more broadly to cover those. And there are two key points I want you to take from that. Firstly, the fact that the proposition that was being advanced, the unifying characteristic, was central sensitization in that narrow sense, a single mechanism. And even if you were only considering mechanisms for augmentation or amplification, which is of course a small part of the overall picture, there are other mechanisms. Central sensitization is one single mechanism. And we see, if we read on to 62, sometimes now known as activity-dependent central sensitization. You get that from the first 4 lines of paragraph 62. And you see, if you drop down to 64, 2 specific types of symptoms are often the result of this, in addition to a summation over time. But the 2 specific types of symptoms are 2 particular forms of allodynia and hyperalgesia: dynamic mechanical allodynia and mechanical secondary hyperalgesia. The point I make about this is it's only those 2 specific things. It comes nowhere near equating the presence of hyperalgesia and allodynia generally. Those are the symptoms where things hurt more than they ought to. My lords will recall my friend explaining that where it would have hurt and it hurts more, or it wouldn't have hurt and it does hurt.
You mean they don't always happen?
What I mean is that the concepts, those symptoms, allodynia and hyperalgesia, is a much broader thing than those 2 specific things that are mentioned.
So you're saying there only are 2 subsets of allodynia and hyperalgesia which are relevant?
Yeah, exactly. And the key thing to take from it is that those symptoms are not a proxy for central sensitization.
Ah. So what are the significance of the words dynamic mechanical and mechanical secondary?
Secondary is to do with the fact that you feel it at a place different to the primary site, and dynamic is that it's, for instance, rubbing rather than heat or something like that. That they're very specific subcategories. But the point that I want you to get is that they are not proxies for central sensitization. And moreover...
How do we know this? I mean, the judge seems to explain them. We were shown these graphs on the right page in terms of central sensitization, but there are other mechanisms which give rise to them.
Indeed, they're much broader.
Yeah.
Was it not? I thought we were taking this from paragraph 62 that what we're talking about at present is a particular form of central sensitization in the narrow sense.
Yeah, exactly. It's important because my friend tries to run a case which is pretty much that one sees a general principle or unifying characteristic because of the presence of hyperalgesia or an allodynia. And that is a very different case. And he seeks to align the 2. And what is interesting, or in fact important for my lords to note, is that the judge specifically ruled that it wasn't open to him, and he rejected it anyway. So if you go to para 349,
Did you say 349?
Paragraph 349,
Right.
I'm sorry. So it's page 814.
Yes.
So this is the judge. And he's specifically saying that there was an attempt to argue, see, the unifying characteristic or principle, he knew that's what he was trying to do, it's the presence of hyperalgesia and allodynia. First of all, the judge said, I don't consider it's open. And secondly, if you go down halfway through the paragraph, in any event, I don't consider the evidence supports it. That is important because my friend seeks to bolster his case by repeated references to hyperalgesia and allodynia, or by referring to pregabalin as an anti-hyperalgesic. It's just the same thing. And when he does that, he's running a different case, and in any event, one that the judge said wasn't open to him, and in any event rejected.
Well, I mean, the one case that wasn't open to him was that hyperalgesia and allodynia were in some way relevant to central neuropathic pain.
The unifying principle.
Yes.
Yeah.
It's unifying in the sense that it was characteristic of all neuropathic pain.
But on your cross appeal, we're looking to see whether they are a unifying factor as between inflammatory pain and neuropathic pain generally, aren't
Exactly.
We've moved on from whether it's peripheral or
We
central.
have, yes. The reason I'm showing you this is because it's important to understand how all of these things fit together when you're looking at what they have actually shown. But I want to make sure that my lawyer got the point that when he says, oh, look, he says things about hyperalgesia or an allodynia generally, he's not doing something which is open to him, and certainly he's doing something contrary to what the judge said was not made out.
But allodynia and hyperalgesia are factors which can appear in relation to nociceptive or inflammatory pain, and in relation to neuropathic pain.
I'm not sure to what extent that's right, my lord. All I do know is that the argument on central sensitization does not allow you to put those general categories as proxies for central sensitization. It's a different case, and you see my friend trying to do it.
Aren't they indicators of there are possible central sensitization, because they're possible results of it, aren't they?
Well, it depends. Depends on where a particular narrow form of those symptoms might be. That is not the same as saying I can take the whole category as a proxy for it. Like all of these things, they're levels of generality. And in fact, that's the fallacy in my friend's case on Salk. It's a specific type where you might have got into that argument, but what you can't do is take the whole category of allodynia and hyperalgesia as a proxy for central sensitization, and you certainly can't take it as the unifying characteristic, because you see, Mr. Justice Arnold...
Of neuropathic and inflammatory pain.
Exactly, yes.
Yeah, because it's not always present.
Yeah, exactly.
Is it simply that it's not always present, or is it that there are different types of...
Yeah, both. Different types.
Different types
It's
of...
allodynia and hyperalgesia. It's just a different case, pitched at a different level of generality.
Well, I think you agreed a moment ago, you are now dealing with whether it provides a unifying feature across from inflammatory pain to neuropathic pain on your cross appeal.
Indeed.
Although the judge here is really looking to see whether it provides a unifying feature between peripheral and central neuropathic pain, isn't he? That's what he says in the first sentence.
Indeed.
So he's not quite addressing the point you're now addressing.
He's certainly not addressing the case I'm addressing, but my friend maybe I should have referred to this part of the technology earlier on as well, because it is relevant to the way my friend puts his first case.
That.
And so
I'm just trying to keep my head on my mind focused on the particular furrow which you're currently ploughing.
You're absolutely right. This is relevant to the way he puts his case earlier as well.
Because, of course, the judge did find that there was, albeit only a narrow balance, I think he said, plausibility in relation to neuropathic pain.
Exactly, and I'm going to explain how he did that.
Yeah.
I mean, could it be a unifying factor if one is focusing on neuropathic and nociceptive pain rather than the distinction between central and peripheral pain? Could it be a unifying factor that in many cases the sufferer is afflicted by whatever mechanism with allodynia and hypoalgesia? In other words, as we all know, pain can sometimes sort of become inflamed, presumably as a result of one of these mechanisms.
The real problem that I'm having difficulty answering that is that the judge said this case wasn't open to him. It just wasn't, it's just not the way it was put.
So where does he say that?
It's the paragraph I just took you to.
349.
Oh, I see. Well, that's going back to the central and peripheral point, isn't it? I mean, the central peripheral point is, I see what you say. It's clear enough.
And the other thing, actually, you've got to bear in mind is that the way the case was put was by a mechanism. It's been put on a mechanism, and these are not mechanisms, they're symptoms.
They're symptoms which can be due to central sensitization, which is a mechanism.
A subset of them can be. But that's quite important, because if you're doing a test where you don't distinguish for that subset, you haven't identified whether or not you're testing for central sensitization. Now, it's been a long time coming, but can we turn up the salt?
Yes. Do we want to operate?
Tab 63 in volume 6. 3446.
I'm sorry, I didn't catch the
Tab
volume.
63 in volume 6, page 3446 of the electronic bundle.
Thank you very much.
It's Board of Appeal, and it's a key EPO authority. As you'll have seen, it's been referred to in Regeneron, Mr. Justice Burse in Hospira. It's an appeal by the patentee where the only claim in issue is claim 6, which is a Swiss form claim, and it's bridging page 345 and 3451. It was use of a compound identified in a particular way to manufacture a pharmaceutical for the treatment of a particular type of stimulated tumour formulation, arthritis, asthma, allergies and rashes.
Sorry, where are you reading that from?
I was reading the claim that bridges 3450, and the indications are on the bit of the claim that goes over to the top of the next page. The objection was sufficiency. So Article 83, and it's turned to para 3 on page 3455. And you see at the end of paragraph 5 in this section, so over the opposite page, 3456, what the patent said about the medical condition purpose. It was asserted to be useful for the conditions claimed. The board explained the patent is not being concerned with giving a technical basis for what is claimed. And you see from paragraph 6 at the foot of page 3456, the same argument as is run before my lords was tried, post-published evidence, all from work done later. And if you go forward to paragraph 7, you'll see an argument familiar to my lords that looking at that work, the patentee said that one could follow the disclosure and obtain the post-published results. So in essence, exactly what's said here.
Paragraph 8.
Exactly. Paragraph 8 is important. We see that argument's rejected. They start by saying sufficiency of disclosure must be satisfied at the effective date of the patent. So that's another express reference to the fact that you've got to have it in your patent. And it goes on to explain on the basis, it has to do so on the basis of the application's information together with the common general knowledge then available to the skilled person. Now, so it must be information that the skilled person knows from their CGK or in the patent. Won't surprise my lords, you can't try to supplement it with knowledge either developed later or even perhaps known by specific individuals at the date of the patent, but not part of the ordinary skilled person's knowledge. The next part of paragraph 8 explains why. And that's that otherwise you would grant a patent for a technical teaching achieved, i.e. the invention made, at a date later than the effective date. At the end of this paragraph you see again the common theme that we keep seeing, the important principle that the monopoly conferred by a patent should correspond to and be justified by the technical contribution to the art. Now, paragraph 9 goes on to explain that important thing about Swiss form claims that I explained in the context of Hospira, the fact that attaining the claimed therapeutic effect is a functional technical feature of the claim. It's the same point. And they go on in the paragraph to explain that the consequence of this under Article 83 would have to be that you would disclose a product is suitable, I did attain the therapeutic effect, but that might take years of clinical trials, high development costs. I'm now at the foot of 3458. And over the page it explains that industry would only bear it if it had some protected rights. So at the top of 3459, about 5 lines down, explains that the patent system takes account of the intrinsic difficulties by not requiring absolute proof. This is all familiar to my lords, having seen Mr. Justice Burse in Hospira. And you see that they note about a third of the way down 3459 that the Boards of Appeal have accepted that it's not always necessary for results from clinical trials, or at least to animals, are reported. So what that's saying is that it's not a rule that you must have one or other of those two. But, and I'm now just above halfway, as the Board explains, that does not mean a simple verbal statement is enough to ensure sufficiency in relation to a claim to a pharmaceutical. And this is the important bit, right in the middle of page 3459, where it says it's a requirement that the patent provides some information in the form of, for example, experimental tests to avail that the claimed compound has a direct effect on a metabolic mechanism specifically involved in the disease, the mechanism being either known or demonstrated that the compound has an effect on in the patent. So if it be shown to affect a mechanism that the skilled person knows from his CGK is involved in the disease, he doesn't have to show that it's involved in the patent. Or if it's not known to be involved in the disease from the patent has to demonstrate that as well. But of course the patent in that case would still have to show the drug had an effect on that mechanism. So in that latter case, where the mechanism's involvement is not known in the CGK, the patent would have to show both the drug's direct effect on the mechanism and the relevance, as it were, of the mechanism in the disease. And I'm rather labouring the point because there's an important point there. One of the errors in my friend's approach is to muddle those things up. They're two separate things. He's hoping that if he can show a mechanism that's involved, you will forget about the need to show that the drug has a direct effect on that mechanism. Now, my lords, the board goes on about 2/3 of the way down page 3459 to explain that in vitro data may be sufficient if, and again this is important, if the observed effect directly and unambiguously reflects the therapeutic application. So it must be direct and unambiguous. Or, as the board goes on to say about 4 lines up from the bottom of the page, if there's a clear and accepted established relationship between the shown physiological activities and the disease. Passage bridging page 3459 over to the top of 3460 is explaining the post-published evidence rule, and I've covered that. And paragraph 10 sets out that the patentee had argued that in vitro tests were irrelevant because no prediction could be made that the effect would be seen in vivo, in effect emphasising that degree of uncertainty of going from in vitro to in vivo. But the board disagreed that in vitro tests were not useful, and you see in the middle of that page, 3460, what they called the protagonists must be made available in order to do the tests. You see protagonists in quotes just above halfway?
Yes.
Yeah, and what they mean by that are the underlying important pieces of information. So it's about providing some degree of knowledge. The board goes on to explain, in particular, about 9 lines down in paragraph 10, the sentence beginning on the right-hand side, this means the skilled person is made aware of the structure of the active ingredient, as well as, and this is the important thing for us, in technical terms, a definite link between the ingredient and the mechanism allegedly involved in the disease state. A definite link. And then the next sentence is also important. The presence of a cause-effect relationship is thus made plausible. And in fact, that's the first time we see plausible. And what that second thing is talking about, that last sentence, is the overall plausible cause. The drug causes a therapeutic effect on the disease.
It's not the first time ever, but it's the first time in this case.
That's what I meant. I do
Yes, I mean, when is the first time ever, as a matter of interest?
Off the top of my head, I wouldn't like to say.
As opposed to sufficiency, right?
But
Anyway.
I certainly was only meaning in this case.
Yes.
So, what matters is, as a matter of substance, what's being described here in the context of sufficiency. And what's being described is what one needs to establish a plausible cause of the drug to establish a therapeutic effect on the disease.
Right.
And can I just spend a minute summarising my submissions on this requirement. First of all, the reason we characterise this as a concession to patentees is the point we saw that strictly attaining the effect is a feature of the claim. And as I've explained, it's of great benefit to patentees when it comes to validity, and they don't actually have to show that it does work. And there are practical reasons for that. But as you've seen, a mere assertion or speculation won't do, and that's so even if it turns out to be true, i.e. the drug has a therapeutic effect. And there's a good reason to stop that, because not only is it unfair to allow someone to claim today and do the work later, it can actually work against the system. It's supposed to encourage innovation, but actually what you do is allow people to close off areas. You remember the first point that we saw in Dr. Fisher's article. So what's needed? You need some technical basis, some information, is the way it's put in the middle of 3459, And the kind of thing that's given by way of example are a direct effect on a metabolic mechanism specifically involved in the disease. Now, the first point I make, it says for example, so you need not do that. You might seek to carry out a clinical trial directly. But SALK is particularly important because it's recognising that one might not seek to make the cause of the therapeutic effect plausible directly.
No, you can prove it theoretically.
Well, not theoretically, because you do have to show the effect on the metabolic mechanism, but you're doing it indirectly. But the reason SALK is so important and so helpful to my lords is because the example they give as to the alternative way you do it, seeking to demonstrate it via an effect on a mechanism, is exactly this case.
Well, it's the unifying category.
Exactly. And it's how you make it, how you establish that.
I know your point is that the metabolic mechanism has to be specifically involved in the disease, and you say that the metabolic mechanism that you're focused on isn't one that is specifically involved across the range of pathologies that they're claiming to treat. Is that the point?
It's a bit more than that. It's the fact that can I actually come to it? Because it comes to two steps, and I'm going to get to it very shortly.
Shall we, since we're sitting a long morning, shall we have a 5-minute break?
Certainly.
Come to it after that. Right.
So, my Lord, what's the position here on what's in the patent? Well, the first tests done are inflammatory pain models. So what you have in terms of what's needed in SALK, a clear and accepted established relationship between the test and inflammatory pain, is clearly there. And that's why it was common ground that there was no issue as to the inflammatory pain claim. But it's not the common general knowledge that those tests are predictive of efficacy in neuropathic pain. That is important. Let me show you that, because there was a big fight about that at trial. If you go to Core Bundle 3, page 787, para 215.
Sorry, can you give me that again?
Sorry, page 787 of the electronic bundle, and 215 is the paragraph down at the bottom of the page.
This is the judge.
Yeah, this is the judge. And you see the judge sets out that this was the effect of a case that Warner-Lambert was running. The third point, most important, they were contending that it was one of the tests was predictive of efficacy for neuropathic pain. And the judge traverses several pages directed to this issue, including extensively by reference to a paper called Yacolt and Malmberg, which the judge notes at para 224 on page 790. In fact, it was never suggested it was CGK. The test was predictive of efficacy for neuropathic pain.
Para 224.
224. It's a point the judge thought was significant about what was not put about that particular paper right at the end of 224. But the upshot is seen at 235 on page 792. So there's a lot of evidence considered. The conclusion is that it's not been established that it was common general knowledge that the test was predictive of efficacy for neuropathic pain. So what does that mean? It means that my friend can't argue that the skilled reader gets a suggestion from his CGK that the tests are predictive of neuropathic pain. The other possibility would have been to get there by disclosure in the patent, but that's not there either. In fact, quite the opposite. My lords may remember seeing that the patent in fact says that the tests show efficacy in inflammatory pain. That's paragraph 21 on page 925 of the patent. It's the right-hand column about 2/3 of the way down. So that might have been
Wait
a
a minute,
way...
let's just find it. Can we just find it? Which paragraph was it? In page?
21.
21, yes. Yes, I see.
Inflammatory pain. So that's one way they might have put it, but well, in fact they did try, but it's not open to them now. So what we have in this case is an attempt to argue for what is needed indirectly, i.e. that some unifying principle can be gleaned by resorting to central sensitization in the narrow sense relied upon by my friend. So it's that single mechanism. They're relying upon a metabolic mechanism, precisely the example the board was considering in detail as an example in Salk. But this case is harder for my friend because the patent specifically says the data show efficacy for a different category. And moreover, as I've explained, drugs that work for inflammatory pain generally don't work for neuropathic. It's even harder because the patent doesn't mention central sensitization as the unifying principle or the mechanism upon which the drug has an effect. So my friend's case must be that the skilled person reads the patent and the idea pops into his head. It must be my friend's case. And it's made even harder in the context of a document which is claiming all pain and making the kind of broad claims that you see in paragraph 3. And I rely on that because it's a totally unnatural exercise in hindsight to pick out a particular subsidiary claim and search for a common characteristic. In fact, it's even worse for my friend because the skilled man knows that if central sensitization had been what the patentee was proposing, he could and would have done a test for that effect. And I get that from paragraph 344 on page 813 of the judgment. This is an important paragraph because it lists quite a few things which are important, including my friend's expert accepting that the idea that a compound would be useful for all conditions listed in the patent is quite extraordinary. But the part I wanted to pick out for my lords is at the top of 814, the finding that the skilled person would realise the data does not discriminate between primary and secondary hyperalgesia, but also that if one had wanted to do it, it was easy. And it's only if you do that that you indicate the presence of central sensitization, as the judge says 4 lines down. So the effect of all of that is they've done a test that doesn't provide any indication of central sensitization or mention it, but the skilled reader would know that if that's what they were seeking to investigate or convey as a unifying principle, they easily could have done. So, my lords, for these reasons, my friend is already on a really...
What is primary hyperalgesia?
At the primary site, the site of the original cause of the injury or whatever it may be. Primary
it's not a referred
Oh, I see.
It's not a referred
it's not a
pain.
referred exaggerated loss. Why do... Yes, that's it. I see. You can have... something that hurts more than usual at its site.
Yeah, absolutely.
And why does that occur? occurs through some other mechanism than central sensitization.
It's all terribly complicated.
Yes,
I
I see.
can't tell you how all
Okay.
these things occur,
Yes.
but I can tell you that that's not part of central.
It just occurs separately. Yeah. Okay.
Yes, I think paragraph 18 of the statement of facts
Facts
and
and
issues
issues.
shows the difference between primary and secondary hyperalgesia.
Exactly.
Exactly. So, my lords, my friend is on a really slippery slope already, but it gets even worse for him because he has selected a case based upon a suggested effect on a metabolic mechanism, precisely what we've seen in Salk. So, we know from Salk that this is an indirect way, and we know it's a two-step process. Remember, step one, the direct effect of the drug on the mechanism itself, in this case central sensitization. Step two, the specific involvement of the mechanism in the condition. And that package, the two links, provides you with a plausible causative link which you need, namely that the drug will cause a therapeutic effect on the condition. It's still a long way from proving it, but if you show that it does affect the metabolic condition and that it's involved, it's at least plausible that you'll get the effect. And my lords, just to be absolutely clear, it is step one where he fails, the direct effect of the drug on the mechanism. And I believe my friend accepts and knows that he must establish step one, i.e. that the patent contains data showing it has a direct effect on central sensitization. Let me tell you why I say that. If you go to his reply case, so that is it's page 364 of the second core bundle. It's the first half of that paragraph. He moves, paragraph 33 at the top. He moves away from it and starts going into his general case about allodynia and hyperalgesia down to paragraph 35, which is the forbidden case that I've explained to my lords on the judge's finding. But it's that very first sentence in paragraph 33. That is the key to my cross appeal. That is precisely step one in Salk. And there is nothing supporting that assertion. So he has, on the findings of the judge, established, at least for peripheral neuropathic pain, that central sensitization is, as it were, something that's going on or involved. So he's got step two, but he hasn't got anything directed to step one. And instead, he replaces it with two matters which are just different. And they're the following two matters. First, the effect of the drug on inflammatory pain. Note that I say inflammatory pain generally, not any specific mechanism. Second, the specific involvement of central sensitization as a mechanism in inflammatory pain. So in effect, the equivalent of step two, but for inflammatory pain. And he tries to muddle it up and hope that my lords don't see the ball slip between your legs. But there is a disjoint in that. There's a logical fallacy. And I've tried to think of a way to illustrate the point. It's something like this. If a professor leaves a lecture theatre full of students and comes back to find something inappropriate scrawled on the whiteboard, he then seeks to rely upon that observation to say that a particular student who was present must have done it. That's what it is. It just ignores all other possible explanations, all the other students. All the observation shows is that someone scrawled on the whiteboard. There is absolutely no logical basis or evidence for the assertion as to what I've called step 1 or the first sentence in paragraph 33. It's certainly nowhere near the required standard that we see in Salk. You have to show a definite link or a direct effect. You've seen those two ways in which they put it in paragraphs 9 and 10. And that's why we've got that assertion in paragraph 33. He knows he has to create the impression that that's what his patent shows. And when my lords ask him about that, you will have lots of references to statements or evidence or findings in the judgment about central sensitization components, or it plays a role in a test. Those are all statements that are just statements that it's a student in the lecture theatre. That's all they are. Be very careful when my friend seeks to address this, because that is the way he will seek to befuddle you.
I mean, the befuddling is presumably the way the appellants would like us to interpret this is the patent contains data, all right, it may refer to nociceptive pain, but nonetheless the data shows that the drug has a direct effect on central sensitization. I mean, you would challenge that.
That's the point.
Supposing it did, then it, if central sensitization is also a phenomenon that affects peripheral or involves peripheral neuropathic pain, then it's quite likely that the drug will work with that as well. And the same sort of argument applies to hyperalgesia and allodynia. It works in the context of inflammatory pain, since those are phenomena that are also found with neuropathic pain, then it might well work with them.
Well, that last bit is the forbidden case.
Yes.
Not allowed. And the first bit, pretty much everything my lord said, yes, but it was the suppose it does point on it
Yes,
shows an
yes
effect.
at the end.
No, it's the suppose it has an effect on central sensitization. Oh. That is the point. The data doesn't. That is entirely the point, and he is going to try and persuade my lords that that's the position.
But I mean, you've taken us to paragraph 344, which of the judge, which, well, the point being made is that none of this is apparent from the specification.
Exactly.
I mean, if you like, 33. Well, I suppose that's really the point, that notwithstanding 33, plausibility requires all this to be reasonably apparent to the skilled expert from the specification.
I mean, your real point is this, isn't it? That the rat paw tests, it was common general knowledge that the rat paw tests assisted in inflammatory pain.
You've got no idea why.
But it could, taking inflammatory pain as being, if you like, caused in one place, then amplified by central sensitization before it impacts upon your perception of pain. There was nothing in those tests to show at which point in that process the drug impacted.
Sure.
And therefore, you say it's a complete non sequitur to show that it impacted on central sensitization. And without that demonstration, when you carry your central sensitization across to neuropathic pain, you don't carry the drug with it.
Exactly. All you've got is two lecture theatres where something happened. That's it. Now, my friend's argument, and in my submission, the analysis in the courts below rather lost sight of this, what I've called step 1, which must be a direct effect of the drug on the mechanism. My friend says the court had evidence, in particular from Dr. Scadding, relying upon observations in the patent. And you see, I don't ask you to turn it up, but he refers to that in paragraph 38 of his reply case. And this is, in fact, Lord Justice Floyd's sorry, let's get this right. Lord Justice Floyd, the quote is in paragraph 131 of the judgment. And so that's in court bundle 3. I think it's 365, no, 575. If you go to page 575, see that what Lord Justice Floyd is referring to is reliance on the evidence of Dr. Scadding. Mentions Professor Wood as well. The emphasis is Dr. Scadding in particular in the passages I've cited. Place express reliance on the observations in the patent. Now that is a reference to the evidence cited 2 pages earlier, 118, which my friend actually read to you by virtue of by going to the actual transcript. But if we can just do the bit on the judgment first. So if you look, it's bridging page 572 and 573. The passage starts to run the case of allodynia and hyperalgesia as common symptoms. So as I've explained to you, not the case that we're considering and not open to him.
Well, you say not open. The paragraph you refer to is the one which deals with central pain, isn't it?
Yes, indeed. You're right.
We're looking at the bottom of 572.
There's no unifying characteristic in the form of hyperalgesia and allodynia
Exactly.
embracing central neuropathic pain.
Yeah. Or peripheral.
Well, that paragraph actually doesn't deal with peripheral, does it? But that's what's troubling me.
But then down to the last question on page 572.
I mean, here is this question and answer. Dr. Scadding accepts that hyperalgesia and allodynia are common symptoms in both neuropathic and inflammatory pain.
Sure.
Yes.
Then the next question, it's a credible claim, isn't it? This is paragraph 3 of the patent. Well, it's credible, but my first reaction, if I may say so, was that these claims for neuropathic pain were based on 2 animal models, which I regard as being models of inflammatory pain. So that, in essence, is the witness saying yes, but the technical basis is a model in inflammatory pain. So my submission is that's credible in the sense of not incredible, not a positive reason to believe. Then the point is put at the top of page 573, all the conditions contributed by central sensitization. So that's really what I've called step 2 in the analysis. The commonality of central sensitization as having a role or being involved. It's one of the kids in the lecture theatre. The same point is put again after the witness says it's odd that there's no mention of central sensitization. And then the final question is directed to one of the tests in the patent, and that suffers from the same fallacy. It's just repackaging the same thing. Broadly this, central sensitization plays a role in inflammatory pain. Formalin test is a model of, i.e. measures inflammatory pain. Central sensitization plays a role in the formalin test.
What does that question mean?
Well, that
last one about playing a role in the formalin test.
It's a kid in the lecture theatre. That's why I've warned my lords, you're going to hear lots about components and roles.
But he didn't deny it. So what's it mean?
Well, it is something which is a mechanism which is involved, but it doesn't tell you that any test where you show an effect of a drug is having that effect on that mechanism. So that's why I say it's the same fallacy. What that question conspicuously wasn't, was that the test showed an effect of the drug on central sensitization.
Is the point that you are currently making about the logical fallacy behind making this deduction from the mere fact that central sensitization plays a role, set out in your printed case the way that you have put it to us? The reason I'm asking that is that this is such a critical part of the argument on your cross-appeal that for my part I would welcome a short written summary of what you say that the central logical fallacy is, because what you're pointing to is an inherent logical fallacy.
Indeed. I thought it was in the bits where we say that the drug has to be
I'm not
positive.
disputing that at all. I just
But
like to be pointed to the place.
Or if I haven't put it as clearly as I hope I've put it to my lords now, I'll put it on a sheet of paper.
Well, if you feel that you need to improve on what you said in your printed case, and I confess straight away that I did not catch the point completely from your printed case, but that often happens when you read something in advance of the argument. If you feel that you need to improve on it, I, for my part, would welcome just a single sheet of paper
Certainly.
in which you explained the point.
I will either give my lords the reference where I say just read that, or I will give you no more than a page saying this is it.
Thank you.
Those in court trying to understand what that question means would have had ringing in their ears the words of Professor Wood on the previous day, I think, because at the moment I'm baffled as to what it means, but I might, I suppose, myself be educated if I could look back.
The judge found, I mean, I was just looking at your case, paragraph 92, which makes, to my mind, the submission you made a moment ago even more necessitous of some further explanation. According to paragraph 92 of your own case, it was common general knowledge that central sensitization played a role, but not the dominant role, in the second phase of the rapport for Mylan model.
Yeah.
So,
but it plays a role. It doesn't. That is just telling you it's a kid in the class.
yeah.
That's step two. It's absolutely
You've no idea whether the drug is actually operating on it.
on that mechanism. Yeah. That is the logical fallacy.
It's certainly reducing the overall pain, but there are a lot of causes for the overall pain.
Exactly.
Yeah.
That, my lord has the point. Now, my friend went to the transcript to take you to that evidence because he wanted to read on to questions about how the skilled person could have carried out the Bennett test if he'd wanted to. But that doesn't help, my friend, because that's just getting into you could do the work later. So in my submission, it's quite clear that the test in Salk is just not met. And it isn't, certainly not meeting the point that the patentee has to make an inventive contribution in his patent. So we say the wrong test has been applied. You have to have some positive basis for thinking that the cause and therapeutic effect is plausible, not just some absence of a reason to think it's possible. And it was quite telling that my friend made quite a lot of his submissions about plausibility by reference to things like inventions against the laws of physics. It's not about that. It's not about cases where you say something where there is a positive reason to think it won't work. It's about advancing knowledge and providing a positive reason for thinking it will work. And in the context of a second medical use claim, where you do it indirectly via a metabolic mechanism, Salk tells you exactly what you've got to do, and they don't meet it. Now, unless my lords have anything further, I was going to move to infringement. Now, my lords, the issue in a nutshell is what kind of additional element does a Swiss form claim incorporate so as to limit the claim to the purpose? The question is ultimately one of construction of the claim, and in particular the word for in the phrase medicament for indication why. And I explained yesterday that these claims are unusual, that something special does need to be done by way of construction, otherwise they wouldn't have a hope of being valid. And I have to say, until my learned friend's submissions yesterday, the matter had always been argued to be a matter of construction of the claim. The idea that one gets into, in effect, simply throwing away section 60, the statute, and rewriting it, the infringement provisions, to apply when the claim is in Swiss form, is, in my submission, a quite extraordinary submission. Another basic point that I think my lords probably already have on board, but Swiss claims are process claims. They are to the manufacture of a medicament. That process is complete when the process of manufacture is complete. And if you just stop and think about it, that is why my friend puts his case on the basis of section 61C. He says the box of tablets is a product obtained directly by means of that patented process. That case could not be advanced if the process was not complete at the end of manufacture. And don't forget, think about a full label product. He will want to say that where the product is a full label product, where they are targeting the patented invention, labelled up for the patented indication, he will want to say that as when I've manufactured those boxes, section 61C catches it. One can just imagine the howls of derision if a defendant were to say, sorry, the box of tablets is not obtained directly by means of the process, because the process extends beyond the process of manufacture. You just see the kind of reception that point would be met with from a patentee. Yet, as I understand, at least part of the way the case is put, that is the suggestion being made.
As an alternative, presumably.
I hope
Yes.
so. I mean,
Yes.
but he definitely is suggesting that. Now, I think my lords have understood a particularly important point, which is the practicalities that are at stake. Warner-Lambert's approach suggests that Swiss form claims are, they say, practically unenforceable unless their approach is taken. But what they're really saying is that we want an approach whereby any conceivable possibility of, I think the way my Lord Sumption put it was any leakage. We want to eliminate any conceivable possibility of that. And if you don't, Swiss form claims are practically unenforceable. So they argue, it must be, if it's foreseeable, for some non-negligible fraction, then there must be infringement. But I think my lords have seen that the practical consequence of that is to take the making of the product for the old, non-patented use back from the public domain. And however they dress it up, it's an argument that an honest generic manufacturer cannot continue to do that which was old, to make the medicine for the old indication.
Well, subject to the argument that you can devise a tort for which the only remedy is an account of profits for that part of the market which is subject to the patent.
Well, even that is devising a tort which the honest trader can't avoid.
That is true.
Yes.
But I think that
That's my point, yes.
what is being advanced in support of this suggestion is, given that this is a tort of strict liability, it doesn't matter that he can't avoid it, and it's not unjust that he can't avoid it if the remedy is limited to the adventitious profit that he has made by selling more of his generic products for a patented indication. I think that's the argument.
It does matter that he can't avoid it, because there will be a chilling effect on people wanting to do it in any event. So it's not adequate to just say it doesn't matter because the patent law of patents is normally strict liability. What an ordinary defendant in an ordinary case can do is take legal advice on whether or not what they're doing is falling within a valid monopoly. And they can take a view. Sometimes they get it wrong, but they can avoid infringing, and that they can decide how safe they want to be to do the lawful act.
Your point is really that it's not good enough in point of law or indeed in practice that you won't have to pay for more than the extra sales that you in a sense shouldn't have made anyway. You're entitled as a, for example, generic manufacturer to regulate your affairs on the basis that you won't infringe. point made by my Lord Hodge yesterday.
Indeed, that is part of my submission, but in fact it goes a bit further than that, because although my friend went off script a bit as to what he was suggesting the regime under the rewritten Section 60 should be, in his written case he's put forward a two-tier system whereby you get into the top tier of, as it were, much more punitive relief, not only if you're intending it, but if you haven't taken all reasonable steps to stop it. So just think about the practicalities of how that works. My friend, I don't know whether he's suggesting that what they would be doing is inviting us in for a chat and being very reasonable as to what they would require, and saying, go ahead, that's fine, you're on the lower tier. That won't happen as a matter of practicality. There will be endless requests for what you should or shouldn't do, which you see actually happened in this case. I'll get my lords the references over the adjournment, but there were a long list of requests on the interim injunction application, and then at the beginning of trial there are other things requested. So after we'd even prepared for trial, there were a list of things that needed to be done. Then some more were identified in the course of cross-examination of our main witness, just out of the hat while he was in the witness box, and yet more demands were made in closing. And that's in the course of litigation. I have to say I wasn't at all clear whether what my friend was suggesting was that there wouldn't be litigation or that there would have to be litigation. At some points, certainly in his written case, I think he says, don't worry, pharmaceutical companies won't sue. But the way in which he seeks to brush off the practical problems is to say that that's all a matter for an inquiry, which of course you only have if you've got litigation. And so it's a totally unsatisfactory practical picture that's being put forward by my friend, even before one gets to the question as to what proportion and what's the royalty or the profit. And there's a big difference between inquiries as to damages for the past. Even Grimmer was a case where there was an injunction, so the infringement was stopping, and you have to have a way of working out what damage has been caused for the past. As I've understood the proposal that's being put forward here, that there'll be some way of having an inquiry to regulate payments that have to be made for the future. I mean, I just don't understand what he's suggesting, to be perfectly honest. And what I do submit is that the idea that generic companies, and indeed, as I've understood the case, wholesalers and pharmacists would not be put off from dealing in products is unreal. The practical reality is what he's asking for is a regime which makes it impossible to do that which is lawful. And my lords, I think my lords have got the point that it would apply to wholesalers and pharmacists just as well, because of the effect of Section 60, subsection 1c. The products would be infringing products, stamped infringement from the minute they're made. But in any event, sorry, not in any event, further, the practical problems and the unjustness of the situation put forward applies not just to the direct infringement case, but it applies equally to a suggestion that there should be infringement on the basis of Section 60, subsection 2. I'm going to come on and deal with that separately and explain why that's untenable. But I want you to understand that everything we say about the chilling effect on the direct infringement applies equally to saying that there should be infringement or could be infringement through that route as well. The inability of an honest trader to carry out lawful acts without attracting liability is a really big problem with my friend's case. In addition to what I say is the radical and unprincipled approach of saying, just don't worry about Section 60, let's rewrite a new two-tiered one. I mean, it is a statutory tort, as my Lord Hodge mentioned, and what my friend is suggesting is that you just rewrite it.
Well, you appear to have rewritten patent law by the Swiss form patents. I suppose some adaptation might be said to be necessary.
You're definitely doing something which doesn't fit within the established regime. But what you're doing is granting a claim that has a construction which is new. You're not changing the law. That's why.
Well, I think that the court, including Lord Justice Aldous, thought that this was pretty unconventional in terms.
Well, it definitely is unconventional.
In terms of the law, but fell in with it for pragmatic reasons, which no one's challenging.
But what I'm saying, my lord, is the way you affect it is not to say I'm going to ignore the statute.
You may. I mean, the statute clearly wasn't designed to deal with this situation, so I agree, obviously, that there is a question as to how far a court can ignore the statutory language, but it may require some thought as to how it applies and what it means in this context. The basic point is that it can't mean anything which has the effect of moving the point of when the patented object or process is complete, which is manufacture, and if you stick at that point, then there are all sorts of consequences down line for the pharmacists in particular, as well as extraordinary chilling consequences in practical terms.
Yes, and in addition, you are substantially altering the balance that's inherent in the patent system, which is why I took some time.
So what do you say the actual limit of your liability is, bearing in mind the rather more limited construction that you advocate for 4? You would accept that if someone put on a generic manufacturer produced a product which didn't have any markings as to use at all on it, would you, that would be exposing to liability? Or what is the nature of the purpose or the intention which we're looking for?
Right. Let me. There are only 2 games in town, as in my submission. There are 2 options. My submission has always been that the test is a purposive claim, and actually the claim requires a purpose. So the manufacturer has to have that intention in the sense of aim.
Are we talking about subjective intention? That's a very odd concept as far as traditional, not just patent law, but large areas of ordinary tort law.
Yes, it is. But what you've got is a claim which is directed to a purpose, and that is a purpose. Another way.
That's subjective, isn't it? Because you can determine what the purpose of whether the generic product has the infringing purpose by identifying the purpose which, as far as the outside world is concerned, it is directed for.
Well, that is the other game in town. That is my lord's suggestion that you look at the what the product's authorised for.
Well, there's a third game in town, although you don't think much of it, which is the foreseeability.
Indeed, but my submission is that the 2 realistic options are those 2. And I do accept that intention is not normally part of patent law, but you've done something unusual to allow these claims. And you certainly addressing, for instance, my friend's suggestion on foreseeability, if you go for that, my lords understand that the practical realities are the chilling effect that we've just been discussing. But another, as it were, more principled way of looking at it is, how does that give it novelty? How does foreseeability give the claim novelty? And the point that I've made in my case is that patent claims are about technically novel and inventive products or processes. And there has to be some nexus, some technical nexus between the thing that you're saying is a feature of the claim and the rest of it. You can always formally give a claim novelty. A process claim I could write out today and write in doing it after the 14th of February 2018. And you look at that and say, has anybody done that with all those features of the claim? No, but there's no nexus between that feature and the rest of it. It's similar where all you're really doing is saying the knowledge of the world has moved on. And that's really what the foreseeability test is relying upon.
It doesn't depend on there being a movement in the knowledge of the world. The foreseeability test is the classic objective form of intention. That's why it's been relied on. The alternative form of intention is a subjective form, which is essentially based on the proposition that if you're going to stop somebody doing something which is lawful, there has to be some kind of targeted intention. At least that is so if you take as analogous the economic thoughts. The third possibility is that you simply look at the form in which the product is offered. You simply say that the question as to whether it's enough to say this is for X and Y, or whether you also have to say not for Z. One or other form of those on the face of it is an objective test which doesn't depend on intention.
Yes. Let me just say something about that not for Z thing. I can't tell, my lords, whether or not that is allowed or not. You have to be a little bit careful about, we're talking about what has to go on a, basically a summary of product characteristics or a pill. They're the two key documents.
It's not addressed to the prescribing doctor.
Well, the SMPC is the document that doctors look at. Then they're usually online now, and the pill is the leaflet in the box.
The SMPC, if I've understood it right, is not what is inserted
no,
in
exactly.
the box,
It's
although what is inserted in the box will probably be derived from it.
quite possibly. One is pretty much directed to doctors, the other is directed to patients. And I don't want my lord to take this as me telling you that it's definitely not allowed to put things like that on, but I remember from the interim injunction application that there are all sorts of rules that you would never conceive of about what can and can't be put on those things. And so I would caution very strongly against just saying, oh, something like, let's deal with it like that without looking carefully. We can look carefully if my lords want us to. It's just I'm not in a position to help you one way or another other than knowing there are rules on labelling which might prevent that. I don't know. But subject to that, what my lord is saying is that you look at it objectively, what does it say it is for? And that is my fallback position.
What if we don't accept subjective intention?
Yeah, and let me tell you why we've always said subjective intention. The difference between the two, as a matter of practicality, we see accepting intention is a concession to patentees, because we wouldn't behave any differently, but it might be said that what's on the label test allows conduct like the conduct we saw in the Dutch case, in the case of Sun, I think it's called. I think it's referred to in our annex. And just to very briefly summarise what happened there, is that you had a public domain indication, I think it was Paget's disease, and a patented indication, which I think is osteoporosis, or I might have got them around the wrong way, but the effect of it was that you had a very small market for non-patented indication and a very big market for the patented indication, and you had a pharmaceutical company that took no steps like the steps taken here and launched very large numbers of products onto the market. Now, those are facts which, on my test, a court may well conclude, very likely one might think, there was subjective intention in the sense of targeting. And in substance, as far as I can see, the only difference between those two tests is that kind of situation.
One possibility is that in different ways both apply. In other words, the generic manufacturer could be guilty of infringement if either he intended subjectively that the product should be used for a patented indication, or by analogy with the cause, or he failed to take the objective steps required in documents addressed to pharmacists and patients, e.g. by simply omitting the patented indication from the list of indications for which the medicine was directed.
I can see as a matter of logic you could say both. I'm not sure that as a matter
one might be evidence of the other.
Exactly.
So they're not totally autonomous.
No.
But they are conceptually different.
They are. I accept that. They are conceptually different.
It may be that either will do.
I'm wondering, patent infringement wouldn't normally involve questions of intention. So
Well, it does sometimes. Section 60, subsection 2 has.
Yes, there's express statutory reference.
Yeah, and that is the intention of the third party further down the line. So it does.
Yes, but I mean the intention of. I mean the infringer isn't normally. It's not normally a question of intention. It's whether you've actually infringed. Whether, as a matter of fact, you've infringed the patent. But it comes into it here because the nature of a patent involves the
Purpose.
the manufacture of the pharmaceutical for a particular purpose. And correct me if I'm wrong, but I would have thought that the scope of that aspect of the patent would be a matter assessed objectively. And if that's so, then I would have thought that there's no reason why the nature of a patent should bring subjective intention of the infringer.
Well, you've got to be a bit careful about that in my submission, because then you end up potentially not achieving the novelty that you need to make sure that you haven't got a monopoly.
Why is that? I mean, you made this submission a moment ago, and you appeared to be relating the requirements for patentability to the criteria for what constitutes an infringement. And I wasn't quite sure how the link arose. But maybe I've just misunderstood your submission.
Well, the basic plank in my submission is that if you have the doing of an act, i.e. the making or keeping, say the keeping of a product, making it for the old purpose. If you've got a monopoly that extends that far, you're back into the problem of taking out of the public domain the acts which the public ought to be able to continue to do lawfully.
But this is only really a way of representing the problem, that you may, you can in this field only do something lawful if you are prepared to accept the possibility that other people may use it in a way that involves unlawfulness. That's the basic problem. And what you've just said, I think, simply restates that.
No, it doesn't.
Is what you're trying to get at that it's not merely that the activity is lawful, but that it is the very activity which, in the public interest, once the patent has expired, the public is meant to be able to engage in with the product.
Yes.
It's the quid pro quo for the original patent,
Yes,
which is now expired.
That's true. And actually, just to answer my Lord Sumption's point, I don't accept that because of the way that the prescribing system is set up, it's conceivable of some leakage, that means anybody is acting unlawfully.
Well, I'm not suggesting that. I'm simply saying that the problem which has led the appellants to make the submission they do is that there is a positive interest, as my Lord Briggs puts it, in the lawful exploitation of technology that is the subject of an expired patent. But it's not something that can be done without running the risk that it will also be used for a patented purpose. That's a statement of the problem with which both of you in different ways are grappling.
Did you put the last point? It's not something that could be done.
Well, in order to, you can't exploit the old, you can't produce a medicine for the old indications, the subject of the expired patent, without running the risk that people will use it for the patented indications as well.
I accept that. Sorry, I was just.
Your case.
That's all I'm saying.
They have to.
Sorry, I just wondered whether you were saying that that was an unlawful use. And
No. I'm just saying that is the basic problem.
I absolutely
which
accept that.
both sides are advancing their rather different solutions.
I absolutely accept that. You're right in identifying the problem. And
does the submission that you've just made do any more than identify that problem and make the point that there's got to be some way in which you can, without infringing, use the product for the old purposes?
No, it does, because when I couple it with what I said about seeking to strike the kind of balances that you see in the patent system generally, it does mean that what you're looking for is a solution that enables the people who honestly want to do that which is old to do so without any significant risk. And actually, what I do say is that doesn't lead to a system where they don't get fair protection. I mean, if you look at the facts in this case, my lords know that we had guidance from the NHS, which was directed to seeking to split the market by brand and
they were directed to do that, weren't they, by the judge?
They were, but they didn't resist it. It was one of those.
Presumably this is all against the background of potential liability. If we resolve the legal position in the way you're submitting, generic manufacturers and certainly not judges won't have any basis for that sort of downstream activity.
Well, as I've understood the position,
there'll be no basis on which you can put pressure on the NHS or anyone to issue instructions to anyone.
Well, the Secretary of State will speak tomorrow, I think, but as I've understood their position, they want to assist in developing a system which does enable protection of Swiss form claims as best as possible. You may have seen the proscript to Mr. Justice Arnold's judgment where he in effect gives a plea for that. And it wasn't just the NHS, there were all sorts of bodies that put out guidance as to what should and shouldn't be done, all with the aim of ensuring that the market for patients who have the patented indication was reserved to Warner-Lambert. And the overall effect of what you have, you can see in the findings of fact that the judge made, which if you go to page 825, for instance, I've got to show you two findings, because you need to know the share of the market and how much they kept. So if you go to 825 at 415, what you see there is that at most it's about 70%, but probably going down. Just so you understand what the 70% figure is, that's the patented indication. So this,
But it's good. Correct. For 70% of what?
Percentage of prescriptions, as I understand it.
percentage of the whole market. So everything
that is written for the patented indication.
Yeah. that was an assessment as to when pregabalin is prescribed, what is the doctor looking at in terms of what the patient's got in front of him? 70% of it for the patented indication.
I mean, pain is a more common condition than epilepsy or GAD.
Exactly.
That's why I was surprised when you said it was going down.
Oh, well, that's the finding.
That's the finding.
Yeah, that's the finding. And so that's how much of...
Oh, I see, because of psychiatric conditions continued, yes.
What was the other paragraph that you were getting?
The other paragraph is 560 on 849. What that is a finding as to the combined generic share after they've been on a market for a while at trial. Those names are the generic products. You see the active...
We've got to compare that with the 30%, thus demonstrating, is this your point, that the generic manufacturers are not selling a larger proportion of the market than is consistent with the proportion that the non-patented indications have.
Warner-Lambert have kept 82.6 of the whole market with all these measures where people have been trying their best. And
so there's leakage in both directions.
Warner-Lambert have reduced the price of their product in order to compete in the no longer patented market. So I'm not sure how much we can read out of these.
Well, you can't read too much into that fact either, because I think what my lord is thinking about is a reference in their case to brand equalisation deals.
Yes.
Yeah, and what that is an attempt to, in effect, get the expensive patented indication to subsidise the non-patented indication, and they offer overall deals for quantities to certain customers.
Yes.
But those deals do not include, as I understand it, requirements that they don't take generic product as well. They would like you to think it does, but be very careful about that, because I think what they want to give you the impression of is that those customers are X% of the market and it's the totality of their needs. So I understand why my lord says, well, there's a point there that may make the numbers, what can I get from it? What I do say is if you stand back and look at it, you've got a picture of a market where the patent covers 70% of it, and you've got them keeping 82.6 of it, 82.6% of it, and then you judge their plea that unless you go for a foreseeability approach, that Swiss form claims are practically unenforceable, and that people will not have the incentive to do the work. I say those numbers tell a very different story. They show that, in fact, they are doing very well at keeping...
subject to all the safeguards, and I mean, you assure us that the safeguards are going to continue, but basically you're arguing for a legal position where they can simply put the generic product on the market and leave it to do its best, or whatever.
No. That's my fallback position. That's my Lord Sumption's alternative. That
well, the fallback position, which looks for something that is objective in the actual conduct of the generic manufacturer. I mean, I suggested that it would be the way in which the product is sold, identified, presented, but these are examples of what the reasonable steps are that somebody can take in order to justify his suggestion that something is a product for a particular indication. It may be that more than that is required, it's a question of fact. But on that point, can I ask procedurally, who is it that sets in motion the process by which the NHS sends this kind of guidance out? Now, in this case, the judge gave directions, and as you say, they didn't resist it. But let's suppose we're not in the field of litigation at all. Is it a matter which the patentee would normally prevail? Is it something the patentee would normally prevail upon the NHS to do? Is it something which the generic manufacturer can ask them to do? How does it happen?
I think the answer, on my feet, I think the answer is either can, and certainly the evidence was that the patentee ordinarily, when patent protection is coming up to be lost, the end of exclusivity, they usually have quite a project going on as to how to deal with that. Yeah, and the evidence that I think is actually covered in the judgment a little bit, Miss Justice Arnold's judgment, that is that they do seek to work out how they deal with that problem, and certainly on the facts of this case, there was quite a lot of correspondence with bodies like the NHS and others, like doctors' bodies and pharmacists' bodies.
Correspondence between the patentees?
The patentee, definitely, and also actually my clients.
But the patentee, is the patentee in any way dependent on the cooperation of your clients in order to set this kind of guidance procedure?
No, not as far as I understand it, because
my understanding too.
Yeah, they can just write and say this thing is coming off patent. We've got a second medical use use patent, which will mean that we'll have this problem. We'll have a patented and non-patented share of the market. We would like doctors to be directed to prescribe by brand, and it's going to happen in 6 months' time or whenever. I'm pretty sure of that. They'll tell me behind over lunch if I've got it wrong, but I don't think there's any reason that that can't happen. And indeed, I think pretty much that did happen in this case, save for the fact that the NHS didn't know, there was no established procedure as to what had happened or what to do in the past, and so things didn't happen immediately. But as far as I understand it, in the future, there's nothing to stop that kind of thing happening well in advance of the loss of exclusivity.
Yes, that was Mr. Justice Arnold's view, because he said it behoves patentees who want their second medical use patents enforced to provide the NHS with the information in advance.
Exactly. And one can see actually that if you've got all of that and you've just got a rule that you have a proper label that excludes on the generic, that may well be perfectly adequate protection for the patentee. One thing I should say also, and it's rather against myself, but the suggestion that my Lord Sumption makes about look at the label.
And the leaflet.
Yeah, exactly. In the medical, we usually say the label, and we mean all those documents.
I mean, sorry, go on.
I was just about to say that I said it probably wouldn't make any difference between that and intention for the manufacturer. The label test does make things much clearer and more certain for wholesalers and pharmacists. And as I say, it's slightly against my primary position because it means that they can actually be sure by looking at the box rather than having to trust that the generic that they trust didn't have the intention. So when you think about the effect of section 60, subsection 1C, the label is giving those particular entities in the chain a much greater degree of certainty. I suspect, as a practical matter, for manufacturers, and by that I mean my clients, even though we subcontract the manufacturing out, the only practical difference is probably the kind of Sun Pharma case in the Netherlands. Sorry, my lord had a question.
Yes, I really come back. I was just looking at Mr. Justice Arnold's treatment of this, which is quite extensive, but it's all against the background of current litigation, isn't it? And it certainly includes some quite forthright threats about potential patent infringement by pharmacists, or indeed even by NHS, Highland, in relation to an article about the prescribing of pregabalin. So it's very difficult to transpose that situation to the situation which would exist after this judgment limited the steps required in the way which I thought was your primary case. You say is your secondary case. I thought your primary case was that the intention was subjective. And,
Yeah, that is my primary
yes,
case.
Right.
Yeah.
Well, anyway, what about the basic point that we really can't transpose the sort of steps that have been taken in the past, in this case, into the future necessarily?
Well, in my submission you can, because that's what's being mentioned there about the threats is actually a point in my favour, because what that goes to show is what this particular patentee and what others in its position are likely to do if you have a test which enables them to say that there is infringement. That's what that's about, that there were threats made to pharmacists that they would infringe.
But as soon as they can't say, mount that plausibly.
But they can on my friend's test. My friend's test.
No, well, of course.
On your test, if you ask yourself, should they also set in motion these administrative processes within the NHS? It does arise, doesn't it?
Should they take any steps at all? As long as they get the technical labelling right and query whether that has to actually include a positive injunction that this is not for pain, whether it could include that. But as long as they get the labelling right on your test, they send the packaging off saying to themselves, well, it's perfectly obvious to us that quite a bit of this is going to be sold for pain, but we've done our stuff.
No, that's my clients did.
I know, probably wouldn't put it like that, but
my
that's
clients
the net
did a lot
effect.
more than that, and they would be at risk if they did something a bit like Sun, even if the market wasn't such that made it so obvious.
Producing the medicine with no indications at all.
Or even a skinny label and
Yes.
and taking you can't you have to have an indication.
Yes.
But
you say that's all you have to have.
yeah, but
You
what
just
I,
have to have an indication. This is for epilepsy and...
yeah, but what I say that my proposal gives the patentee that just labelling doesn't is an onus. But without going too far, it gives them an onus for us to make sure that we do take some steps, because otherwise we run the risk of a finding that we intended, like you might see in the Sun Pharma case.
That assumes that intention is the criteria.
Yes, it does. That's
one of the points in this. The essential difference between the NHS procedures for advising, prescribing doctors and pharmacists and the labelling and the instructions in the box and all the rest are part of the process of manufacture.
yes.
Whereas the procedures that the NHS may put in place are not only procedures that the patentee can initiate in defence of his own interests without the cooperation of his potential competitors, but are not part of the process at all.
I agree, and the patentee can do that, and Mr. Justice Arnold has basically said they should do. And what my submission is that when that kind of thing happens, and it won't just be the NHS, there are trade bodies that have pitched in as well. When that kind of thing happens, you're likely to see the kind of effect that you've seen here, whereby the patentee keeps a much greater proportion of the market than just the patented share. And that is fair. That is fair. They do get the bulk, or in fact on this, they're probably getting more than they should. But I suppose they say they're entitled to compete for the non-patented market as well, so that, and I accept that. But you look at the numbers and you think, is there an unfairness in what's happened here? And my submission is no. That might be a convenient moment. I've got very little more to do before I hand over to my learned friend, probably less than half an hour.
You're handing over, yes.
I was going to hand over at lunchtime, but we lost 25 minutes to my learned friend going over. But
Well, we'll look forward to resuming it too.